Real estate investing can be a great way to build wealth and is often a go-to strategy to create generational wealth. Now, there are hard assets that can be passed on to the next generation and used to generate income in the form of rent or be used as collateral for loans to fund other wealth-building ventures. If you or your parents have a second home or some commercial property, the question of what to do with the asset is an important one. Should your second home or investment property go into your trust, or should you put it in something like an LLC? Well, that's what we'll be addressing today, so let's open a file. I'm attorney Andrew Bethel, and I want to thank you very much for watching. If you find this video helpful, please hit the like button. If you want to see more, please subscribe and ring the bell, and of course, leave a comment below if you have any questions or have a topic you want me to cover. I try to reply to everyone, so feel free to drop in and say hi. To start, the baseline rule for what to do with any real estate you might have, whether it be your primary residence or an investment property, is to put that property in your trust. You've done the work to acquire some property, so you may as well keep the most you can in your estate and not shackle your family with the big legal and court fees after you pass on. Put it in trust, avoid probate, maximize your estate value, and keep the money in the family. I talk about this all the time, so I'll leave it there. Now I know what you're probably thinking, what about an LLC or an S-Corp? I heard those give me creditor protection, whereas a trust might not, and how does this affect my taxes? If so, great, your mind is in the right place. I've already done a deep dive into when to use an LLC versus a trust, so check that out if you want some more details, but to be brief, there are different considerations on whether you want to use an LLC type structure versus your trust. In this case, if it is truly a second home or just one investment property, you're not building a real estate empire just yet, then titling that property in your trust is going to be your best bet. If you have real estate, then you're going to have a trust regardless to avoid probate, so use it for its intended purpose. Hold assets to avoid probate. Managing the property is just as simple as if it was in your name alone, as it doesn't change what you can do with the property, whether it be sell it, refinance, borrow against it. Your property and personal taxes won't change since it's just an asset that you still own. And if it is a property that you are renting out, it's generating income, then the easiest strategy may be to simply hire a property managing company and have good liability insurance, something you should have regardless of whether it be in your name alone, in the trust, or an LLC. If the property is not generating income, it's truly a vacation or family home, then there's no need to add the complexity of an LLC and the yearly minimum cost of keeping the LLC in good standing. Now, if you have multiple properties that are generating income, you're really building a real estate empire, then the strategy will likely be to pivot to an LLC type structure. But again, go watch my video on LLCs versus trust for a deeper dive on that. Next, with real estate prices being what they are in California now, you might be thinking about investing in properties in other states. Let's say you have a California trust and live in California, but you have another property in Idaho. You can put that Idaho property in your California trust and not have to worry about probate in California or Idaho. We don't care about Idaho's probate threshold since the property is in trust. Let's check. All right, let's see. Idaho probate threshold, $100,000 gross estate, real estate regardless of the value. Got it. All right. We don't have to worry about Idaho at all. I suppose you could have a separate Idaho trust to hold your Idaho property and a California trust to hold your California property, but that just creates complexity and headache. Now the family has to administer 2 trusts, get 2 EINs from the IRS, get 2 trust accounts, 2 trust tax returns, and this would only create infighting if the terms of each trust aren't identical to each other, so just do 1 trust. Plus, even if you move from California to Idaho, you can simply amend the trust to make it an Idaho trust once you get there, but not have to worry about retitling assets since we're keeping the same trust name. Even if you didn't do that, your California trust will be recognized as a valid trust in Idaho, so long as it was valid in California when it was executed. So at the end of the day, put everything in your trust, your first home, your second home, your commercial lot, and even that LLC that manages your real estate empire. Put the LLC in trust because the value of that LLC will count towards the probate threshold. So take it out of the equation, put it in the trust, and manage everything from there. It's how the rich folks do it. It's how us regular folks do it. Click here to learn what a spendthrift trust does and whether it can protect you or your beneficiaries against creditors. Or check out this other video.